Please be seated. First case on our docket this afternoon is styled People v. Travis. Set this for a 1-hour argument. Both counsel look ready. Mr. McReynolds.
Good afternoon. May it please the court. Kevin McReynolds on behalf of the people. The two questions before the court today relate to the right to counsel of choice. That is the underlying basis for this court's Brown test and the special circumstances that require its balancing test. Now, the majority below made two related but separate errors. First, the Court of Appeals erred in extending Brown to a case in which defendant had not invoked and did not have a right to counsel of choice. And second, the Court of Appeals ignored sort of the subtle distinction between a continuance and a choice of counsel issue when it comes to assessing prejudice and whether a reversal is necessary. Now, Brown presents exactly what this case is missing: the factual predicate showing of an invocation of counsel of choice. In this case, in this court's most recent case involving this issue, Ronquillo, the court defined counsel of choice as, quote, the right to a particular lawyer regardless of comparable effectiveness. Or as the United States Supreme Court's Kaplan decision more thoroughly puts forth, the right to be represented by an otherwise qualified attorney whom defendant can afford to hire or who's willing to represent the defendant even though he's without funds. Now, in Brown and all the cases which this court cited in creating its multi-factor balancing test, the defendant had selected a particular counsel of choice who was ready and willing to represent the defendant if a continuance were possible. And thus courts were left to balance the defendant's right to have selected particular counsel represent them against the problems and inequities of having a last-minute or trial day continuance request. This case, by contrast, does not involve counsel of choice. Travis did not identify any particular attorney they wanted to hire, that she wanted to hire. Travis did not suggest that she had the financial ability to do so. Travis did not proffer any suggestion that she had actually spoken to any counsel. Instead, she said, quote, my request is that I was going to look for and pay for an attorney. On the morning of trial, after a year the public defender's office had been representing her, after a 5-month continuance that was granted over prosecution objection, on the day of trial, she said simply, I want to go look for a private attorney. That is insufficient to invoke the right to counsel of choice. She had, to put it simply, not chosen any counsel.
So, well, no, please go ahead.
Mr. McReynolds, how would we define when someone has the counsel of choice? Do they have to physically be in, where do we draw the line? Do they have to be in the room? Do they have to say their name? Do they have to be retained? Where are we on that?
I think that the definitions of the right from the United States Supreme Court are a good indication. First of all, I think it's a little different here than in Ronquillo because we do have no retained counsel but appointed counsel, and that is a factor that we have to look at in terms of, while Ronquillo, we had a retained counsel, you've already got a counsel of choice. There's sort of an absolute right involved there at that point. But when you have appointed counsel, you have to show that there is, in fact, an attorney who is ready and willing to represent you. That is, I think, what the line should be. That's the definition of this right, is if there is such an attorney who's ready and willing to represent you. We're now in the situation like Brown, where we have a particular identified counsel. I want this person to represent me at trial. Therefore, we need to balance the equities of that ancillary constitutional right to be represented by a particular attorney versus.
Can I follow up on that? As a old trial guy, I mean, they're going to say, Judge, I'm hiring, Betty Smith. Well, she's not in the room. How do we, when you say ready and willing to represent, how do we, again, define that? Is it Does the attorney have to be in the room? Do they have to enter an appearance? Does a retainer have to be paid?
I think when we're in that sort of a situation where I've identified somebody, but we don't have any information about that, that's the, hey, let's get the information needed to see whether or not we have these factors met or these factors not met, and that's sort of where we're applying Brown in terms of, like, is there an invocation that we now need to inquire further? Yes. Assuming that it is something, that is within the bounds of reality. If it's, hey, I'm hiring Johnny Cochran and he's going to need 3 months, we all know Johnny Cochran is dead, so we don't need to have make a further record on those circumstances. But on circumstances like here, where we have nothing more than, I'd really like to go do it, or I want to raise funds to do it, or I think I'm going to have money to do it. That's not a counsel of choice issue. That's a general continuance request that's reviewed under general abuse of discretion standards, and those are the standards that should have been applied here.
May I follow up?
Yes.
Well, often you have folks who'll say at the 11th hour that they're interested in hiring Betty Smith, and let's assume Betty Smith is alive.
Okay.
And, she's a criminal defense attorney, but, well, have you paid a retainer? No, but, I'm making arrangements through family members perhaps to do that. So I guess I ultimately have the same question.
Right.
Where do we draw the line? When is Brown triggered?
I think we do need to have some sort of a showing that that person is in fact ready and willing to represent. Going back to Justice Boatwright's point, like what is that level? I don't think you can define a hard and fast. Is this identifiable lawyer actually willing to represent this person? And factually, what do we have to have that? I think will vary by the circumstances. I think your hypothetical would still not quite be enough, because so you want to hire this person, but can you actually hire this person? Is this person actually willing to represent you in this trial? Do you have any information that you can give me that shows that that is in fact met as far as
I have an appointment with
invocation?
him tomorrow.
I have an appointment with him tomorrow. Well,
Or her, Betty. We're sticking with Betty.
We'll stick with Betty. Did Betty say that she would do this case? Yes or no?
Well, Betty's usually going to say, bring me the money, and I'd be happy to help, But if the defendant's been in custody for a long time, or the case has been pending for a long time, I suppose the natural next question